Hi, welcome to the Blockchain Law Show. I'm your host, Anki Kwan. I'm a California lawyer, and in this episode, I wanted to discuss what the SEC has said about bounty programs. In the SEC's case against Tomahawk LLC, they spoke out the first time about bounty programs. In Tomahawk, the company decided that they were going to raise money with an ICO. At the time, in 2017, ICOs had become a very popular way for companies to raise money. Some company raised millions of dollars with an ICO in a matter of seconds. And the word on the street at the time was that ICOs are not subject to the securities laws, in part because some issuers thought that they were selling so-called utility tokens, which are not securities. As such, they aren't subject to federal securities laws, or they believed. So before Tomahawk was able to raise money, the SEC came out with the Dow report. In the Dow report, the SEC investigated whether the issuers of Dow tokens were offering and selling the tokens in violation of the US securities laws. They concluded that yes, they were offering and selling the tokens in violation of such laws because first, the Dow tokens are securities, and they decided that they were securities using the so-called Howey test. And because they're securities, the issuers of the Dow tokens were required to register the offering or find an exemption to registration. Because they did neither, they were in violation of the law. At the time, the SEC did not decide to penalize the issuer in any way, but this was a warning to the community that even though you're doing an ICO, you're not exempt from the federal securities laws. So the Tomahawk CEO, he sees this report and he decides that he was going to avoid the SEC by doing a bounty program instead of raising money through an ICO. He was going to give away his tokens for free. And in exchange for this, he would have people promote his company and his tokens, and this would also create a public market for his tokens and generally create interest in his company and his tokens. The SEC went through the Howey analysis to determine that Tomahawk tokens are securities. They also applied other tests to determine that Tomahawk tokens are securities. And because of this, if Tomahawk decided to offer or sell their securities, they are subject to the securities laws. And again, this means either registering the offering or finding an exemption to registration. So Tomahawk probably thought, this doesn't apply to me because I'm giving away the tokens for free. So the Howey test consists of several prongs. One of the prongs is that there has to be an investment of money. So Tomahawk may have thought, well, I'm not accepting any money because I'm giving away the tokens for free, so I don't fall under the money prong of the Howey test. But the SEC has emphasized over and over again that the Howey test is a flexible test, and it's used to capture many schemes that you can come up with. So you're not supposed to apply the Howey test in a rigid fashion. So the SEC didn't think that you are required to give money in exchange for the tokens. Anything of value would suffice. So the fact that Tomahawk didn't raise any money in their bounty program and they gave away these tokens in exchange for people promoting their tokens and their company, the SEC found that this was enough to find that there was an offer and sale of securities. So if you are soliciting people to do things for you in exchange for your free tokens, or if you're giving away your tokens in exchange for people doing certain things for you, then this is an offer and sale of securities, and you have to either register your offering or find an exemption to registration. This is assuming that your tokens are securities, of course. So before you make a single offer of a token to anyone, it's important that you go through the analysis and figure out whether your token is a security. A good starting place is Howey. Howey is the test that the SEC used in the Dow report. The SEC applied the Howey test to ICOs after the Dow to determine that issuers were in violation of the securities laws. So Howey is a good place to start, but as we see from the Tomahawk case, the SEC isn't limited to using Howey to determine that your token is a security. They can also use other tests. And in fact, they did use other tests in Tomahawk to decide that Tomahawk tokens are securities, but they also used the Howey test on top of it. But the point is, the Howey test is not the only test that the SEC can use to decide whether your tokens are securities. They are allowed to use other tests as well, and they probably will use other tests if it applies to your token. So the first step you should take is to decide whether your tokens are securities, and if they are, before you offer a single token to anyone, you have to register your offering or find an exemption to registration. The SEC is taking more aggressive actions against companies that do ICOs, and even though in the past they didn't penalize issuers that weren't committing fraud in connection with their ICOs, they are doing that now. Recently, as of the date of this recording, it was yesterday, the SEC released a press release saying that they had charged 2 issuers for violating the registration requirements of the securities laws in their ICOs, and they fined them $250,000 each. And in both of these cases, it didn't appear that the issuers were doing anything fraudulent. They simply didn't register the offering of their tokens, nor did they find an exemption to registration. So they were fined because of that. I hope you found this video helpful. If you did, please share. Thanks for tuning in, and I hope you have a great day. Bye.